mentioned before, and because we think that is not one spot conference. We want to maintain somewhat. I talk about the forum should be a think tank, I don't know, but conferences are made to exist until the problems are not solved. And now, so we have the video.
Dr. Gérardine Goh Escolar is Deputy Secretary General of the Permanent Bureau of the Hague Conference on Private International Law and head of the International Commercial, Digital, and Financial Law Division. Her work focuses on central bank digital currencies, digital tokens, and private international law implications related to the digital economy.
Thank you very much. I'm going to keep all the panelists here, I think, while I try to be short and brief. Distinguished colleagues, guests, fellow travelers in this evolving landscape of finance. First, let me agree with Professor Zati. I am the Deputy Secretary General of an intergovernmental organization called the Hague Conference on Private International Law. We are 132 years old. The very first conference was held in The Hague in 1893, and from there derives the name of the oldest international organization in The Hague. So yes, we're going to keep existing until the problem is solved. And I'll talk about those problems in a little. I do like the existing thing because at least there's a paycheck at the end of every month. Probably not a check anymore, but we discussed this as well yesterday. Now, ladies and gentlemen, it is an honor to deliver this closing keynote at a moment of both promise and uncertainty in the story of money. Now, over the past few days, we've dissected a lot of frameworks and we've debated policy. We've glimpsed the future where the complexity is such that we're only beginning to grasp it. So today, I've tried to weave our diverse discussions into a single narrative that's grounded in international law, in the legal frameworks that also underpin the economic structures that we have, that is shaped by historical memory and is animated by a shared concern for global governance and freedom in an age of digital money. Now, to understand where we're going, we must, of course, first recall where we began. You are probably familiar with this book. I had to go back when I had this, when I was invited here. I went back, I think, to a book I read 12 years earlier when it first came out, Felix Martin's Money, the Unauthorized Biography. Those of you who've read the book will remember it opens with this parable about the story of the Yap Islanders and their giant stone coins they called a rai. Now, for those of you not so familiar with this story, the Yap Islanders were, at the point of time, a pretty isolated group, a community of people. And they had a system whereby there were these giant stone coins, which were actually mined on an island about 300 miles away from Yap Island, and then shipped across. And those coins, they were huge, so they were approximately the size, they could go to the size about as high as 3 men, as high as the palm trees, essentially. They were enormous, they were immovable, they were never physically exchanged. Instead, the ownership of the coin was transferred through social consensus. There was a declaration or a recognition, a memory, even a myth. So the richest family on that island, no one had ever seen the coin that purports to be the source of wealth of this family, because apparently it shipwrecked off the coast of Yap Island as it was being transported. However, the legend of the size, the quality of the engravings on this coin was kept for generations. And several generations after that shipwreck, that family was still considered the richest family on that island. Now, what's special, of course, is that money in that system was not a thing. It was a relationship. It was a system of trust. It was a legal fiction. Now, this account, of course, upends the conventional narrative that we have, that money is evolved through, barter first and then commodity exchange and so on. And it reminds us that money is not defined by materiality, but by its institutional and legal underpinnings. And so as Martin concludes, of course, he says, and I quote, "Money is not a thing, but a system of credit that credit accounts and their clearing." Now, we find resonance in this with Jeffrey Ingram's The Nature of Money. You will know this as well. He argues that money is a social relation of credit debt, denominated in an abstract unit of account and legitimized by authority. Money, he asserts, is always entangled with the state, with law, with the political order, with the economic structure. And in fact, the ancients of Europe also understood this. Richard Seaford, in Money and the Early Greek Mind, shows us how the emergence of coinage in archaic Greece catalyzed a transformation in human consciousness from ritual-based economies, so I owe you and I give it to you, you owe me, to abstract impersonal systems of value. And money made possible not just markets, but also by metaphysics. Likewise, Philip Gerson's in the Origins of Money reminds us that the earliest forms of money were not commodities, but accounting systems, tallies, ledgers, and credit instruments, which were administered by temples and courts. And the shift to coinage was actually political rather than inevitable. I could go on, of course, but these foundational texts reveal a common truth that money is not an object. It is a moral, a legal, and economic institution. It is a framework of norms, rights, and obligations that bring us all together and which organizes our economic life. Now, in our time, we stand at the cusp of a pretty similar epistemic shift, the emergence of tokenized money, programmable, borderless, algorithmically enforced, demands a rethinking of legal categories and financial architecture. And this can be illustrated, I think, by the evolving meaning of the word token. So we used to say that money was a token. It represented some sort of value. So it was a token, it was a medium of exchange, it's a means of payment. So what is money a token of, actually? Well, today, in particular, the word token has taken on a different meaning. Our minds go directly to digitization and decentralization. What is a token? Is it merely digital? Must it be on a ledger? What is a ledger? Is it a security? Is it a commodity, unit of account, or is it a novel hybrid of all of these? And who bears liability when smart contracts, which are neither smart nor contract, we're told, fail? Or when digital wallets are compromised? So in a token economy, as we've heard over the last few days, we have to evolve legal definitions of ownership, possession, custody, intermediaries, and settlement that are fit for a dematerialized, possibly decentralized system. And now we ask the question, is it truly decentralized? Now, the legal challenges of tokenization are not merely technical, they are conceptual as well. And so we have distinguished between monetary form and monetary function, and the design and regulatory approaches that recognize this disaggregation. Now, as central banks move from exploration to implementation of CBDCs, one deep constitutional question arises. What does it mean, and we discussed this, so I'm not going to go into it, what does it mean for a digital asset to be legal tender? What does legal tender mean? We've mentioned this today. It is not a symbolic thing. The status is not symbolic because it confers privilege. There's mandatory acceptance, we discussed this, the discharge of debt, institutional backing, final settlement issues, and so on. And embedding digital legal tender into our monetary constitutions then raises certain issues. Can programmable money carry expiry dates or conditionality? Will the public sector crowd out private banking intermediation? Will capital controls become frictionless and invisible? Now, CBDCs may recalibrate the balance between the state and market, between privacy and surveillance, stability and competition. They are monetary tools, they're policy tools, and they're also an infrastructure revolution, all wrapped up in one. But of course, the promise of CBDCs and digital tokens hinges on the technological design. And so the call for IT openness and alignment is so important. Scalability, privacy, resilience, robustness, and cross-border operability are not given. They're not even given within the same country as we heard with the blackout in Portugal and Spain. Now, they are engineering challenges with great legal consequences. So should CBDCs, for example, be token blockchain-based or account-based? How will we handle offline payments? What happens with the robustness of electronic and digital systems? What governance structures will oversee the source codes of national currencies? Now, these questions are, of course, primarily for technologists, but not only. They demand a new literacy among lawmakers, regulators, and central bankers. Now, Lessig reminds us code is law, but we wonder in a digital monetary order, the code that defines transfer, access, visibility, that encodes our values, will it encode those values? Fairness, accountability, inclusion, or the lack thereof? And yesterday we heard the importance of embedding regulation and private law frameworks into the coding of CBDCs. So I think innovation and regulation need not be adversaries. Indeed, they must be partners. And regulation in this domain must be modular, proportional, and collaborative, and certainly not static or reactive. From dynamic licensing regimes to regulatory sandboxes, there is a new governance ethos emerging, one that treats financial regulation as an ongoing dialogue, the one that we're having right now, and not a one-time imposition. At the heart of this is the need for regulatory humility and institutional curiosity. Why? No single regulator has all the answers. We must share data, coordinate supervision, and build collective foresight capabilities. So we heard it put plainly to us yesterday. One of the great advantages of digital currencies and CBDCs, whether crypto or otherwise, is its potential to finally revolutionize trans-border and cross-border payment systems, to do something about the scandal of how long it takes and how much it costs for cross-border payment systems to work. Now, digital currencies transcend borders, but legal systems in jurisdictions, home jurisdictions, do not. And the result is then a web of fragmentation, possibly, and inefficiency. And here, if I may, private international law might be one solution, one stopgap, until we get to the future that we've heard so much about. Private international law, as developed by the Hague Conference on Private International Law, we call ourselves the HCCH, it's hard to say in any language, so I'll just say Hague Conference, offers tools to navigate these challenges. Conflict of laws, mutual recognition, and enforcement mechanisms are indispensable in the cross-border circulation of digital financial instruments. Now, the Hague Conference is an international intergovernmental organization consisting of 92 members, 91 member states and the European Union as a member, the mandate of which is the progressive unification of private international law. And by that, we mean 4 pillars. First, the choice of forum and the grounds on which to base jurisdiction to hear disputes. Which court, which forum is competent to hear? Second, choice of law and the rules to determine the law that's applicable. Which law would apply? Third, recognition and enforcement of decisions across borders, the mobility of judgments and decisions across the limitations of one jurisdiction into another. And last, international cooperations. And these are the mechanisms that allow for the issues to be cooperated and coordinated on. So the Hague Conference focuses on what looks to be procedural issues in private law. Now, we talked on substantive private law yesterday. This is procedural. This sounds remarkably oblique, probably very unsexy, and in the worst-case scenario, completely off-tangent. So I'd like to answer perhaps an obvious preliminary question. Why is private international law and the work of my organization relevant to this group, to digital money, to the tokenization era, and to the reshaping of legal tender? Because, I would suggest, private international law questions are the first questions one has to answer in any context of any cross-border activity or transaction. And in the digitization, digital and online era, much more in the tokenization era, by definition, every activity has a cross-border element. Everything is now cross-border unless you're in a very enclosed system. And if we heard, as we heard yesterday, digital currencies are to fulfill their great potential to revolutionize cross-border payments, even before any regulation or any private law framework can be established or implemented, it is the private international law questions that must first be ventilated, analyzed, and resolved. Now, how do I mean? Now, first, the significance of the choice of forum and the grounds for jurisdiction. Now, we've heard a lot over the last few days, the issues that are ripe for regulation, for private law frameworks. We've heard experts among ourselves, of course, discuss these issues from the philosophical underpinnings of CBDCs to how we're implementing it today. Yesterday, we heard a plea to consider private law when regulating. But one thing is important. It is the law of the forum that decides on two fundamental issues. First, what public policy considerations apply, and whether there are overriding mandatory regulations that caveat private parties' autonomy. And second, the characterization of the subject matter of the dispute. And therefore, ab initio, the first basic question is, which forum has jurisdiction? What does that imply? It is the rules for determining whether parties have the unfettered right to choose the forum that will have the competence to hear that dispute and whether the grounds for jurisdiction are appropriate. Now, that's the first question that needs to be answered by multilateral stakeholders. As public policy considerations and regulations caveat the application of private law, multilateral stakeholder buy-in is unbelievably important to ensure that any private law or regulatory framework, contractual, proprietary, otherwise criminal even, is not overridden from the get-go. It is also the law of the forum that characterizes the subject matter of the dispute. In plain terms, the law of the forum decides whether the matter is contractual, contract adjacent, proprietary, or otherwise, and therefore which body of law or private law would apply. It is well that there are initiatives that provide model laws and principles that specify the rules to determine the law applicable, but the determination in the first stage, what kind of subject matter are we dealing with, lies with the law of the forum, and that's why we need to answer that question. We, of course, look to applicable law, and there the question of whether parties have autonomy to choose the law applicable, whether there are limits to this party autonomy. And in this room, of course, we're all familiar with the arguments for party autonomy. But in a world that is digital and thus definitionally cross-border, and in a world that is tokenized and thus decentralized increasingly, the traditional connecting factors on the basis of locus seems a little difficult to locate. And therefore, the ethos of decentralization creates some problems, in particular because the tokenized economy does not want to specify which law would apply. This means that the rules that determine the law applicable on the basis of novel connecting factors will become increasingly urgent to discuss. Third, the recognition and enforcement of decisions across borders. This is relatively simple. Today, real-world assets and the digital tokens that represent them, including, for example, CBDCs, they live across borders. A decision that cannot or will not be recognized and enforced outside of the borders of one jurisdiction will find very little use in enforcement, especially in the structure of the global value chain today. And last, how could all of this be tackled? We think through international cooperation. And here, the Hague Conference is proud to note that the international cooperation mechanism put in place have been remarkably successful at building trust and confidence among our multilateral stakeholders and our contracting states. So I'll just touch on a couple of projects that we're working on by way of illustration. A lot of the work started in 2022 at the inaugural Conference on International Commercial, Digital and Financial Law of the Hague Conference. The purpose was to tease out the private international law issues in the global digital economy today. And several projects and topics have proceeded to the normative level, meaning that the Hague Conference has established formal experts groups comprised of experts designated by our members and relevant observer organizations to study the topic with a view towards drafting and establishing a normative legal framework to regulate the private international law rules. Two of these experts groups are relevant. The first, and of course directly on point, we have the HCCH experts group on CBDCs. Now, this was established in March 2024 and mandated to study the applicable law and jurisdiction issues raised by the cross-border use and transfers of CBDCs. This was done with a long-term view based on two things. One, that's the potential of CBDCs, not just within one jurisdiction, but to allow international payment systems to work. And second, that private international law and any legal considerations at all should be considered in the design phase and not the implementation phase of the CBDCs. So at the point of time of the actual design and then perhaps the coding. Interestingly, we've had actually, this group has met 3 times, most recently 6 weeks ago at the end of March. And several members actually sit on this experts group. So Just a couple of interesting points. The experts group has declined to consider currencies outside of CBDCs in the scope of its work, and therefore it excludes stable coins, cryptocurrencies, and digital currencies not issued by central banks, because these are not considered to be direct claims against central banks. It also decided not to include stable coins in the scope of its work, given that stable coins differ substantially from CBDCs because they're issued by private entities and have their own mechanisms to maintain value through pegs with other reference assets or algorithmic controls. Now, this is something interesting because after a year of consideration, the group also decided that private international law issues which stem from the core characteristics of CBDCs apply across board to both retail and wholesale CBDCs. It considered the multi-asset system, which the DREX of Brazil might be transacted on, as well as the retail-facing CBDCs that, while issued through intermediary banks, need no link by way of nationality, habitual residence, or any other legal connecting factor. And the example there is the retail eCNY, the Chinese yuan, that China is currently testing. So we have a bunch of other issues that the experts group is actively discussing, and this is the first time that it's been said to the public. It will be reported in due course. The experts group has decided that in the long term, what is necessary is a binding treaty framework for CBDCs to function across borders. There is a discussion that there must be a forum to decide to have competence jurisdiction, and there then should be discussion on the grounds of jurisdiction that members can accept and sign up to, as well as a rule to determine the applicable law to CBDCs. Now, the second experts group we have focuses on digital tokens. This one is new and was established 2 months ago in March to study the private international law issues raised by what we call digital tokens. We define it as exclusively assigned data, including data representing an entitlement, stored electronically, with features relying on decentralized mechanisms such as DLT. And the work of this group actually includes several streams, including one that is a dedicated work stream to write a parallel instrument to the UN Commission on International Trade Law, UNCITRAL's model law on electronic transport records. This is important because this might apply to a bunch of the tokens and the digital assets that link very closely to CBDCs. This group also looks at use cases, and here it discusses stable coins, including those tethered to CBDCs, as well as Bitcoin that we discussed quite briefly yesterday. On the matter of stable coins, it was suggested that stable coins are unique from other types of tokens and might require specialized rules. And so there will be one work stream that discusses that as well. I'll stop there on the work that we do, but I think that more is necessary. We need legal interoperability. And just as the internet functions through technical protocols, digital finance will require juridical protocols, common definitions, harmonized dispute resolution, interoperable finance, and compliance frameworks. And so what we need to do is to chart the course ahead through legal experimentation. We talked about it in the case, I think, of Australia. Experimentation and piloting, even if it does not result in an implementation of a CBDC, is a success. It really is, because then from there, one can draw a bunch of lessons. And of course, we have to cultivate what Martin, Seifert, Hirschman all called moral imagination because money is not neutral. And so we need to have the system that reflects our social contracts and our social values. We shouldn't sleepwalk into a future where digital money is efficient but unjust, frictionless but unaccountable. That's unbelievably important. And so, drawing on the wonderful program that I saw for this conference, between light and shadow, money is a very good illustration of chiaroscuro. Really, from there, the program that you see as well online invites us to consider the work of Caravaggio. He is, of course, the 17th century Italian master who revolutionized painting with the dramatic interplay of light and of darkness. And in his canvases and in the ballet we saw yesterday, light doesn't merely illuminate, it reveals and it judges. It defines morality and it defines ambiguity in a single stroke. And so money itself, money too, is chiaroscuro. It illuminates value, it facilitates exchange, it reflects a system of trust, but it also casts shadows. It can conceal power, it can enable inequality, it can manipulate perception if not properly communicated. And so, as with Caravaggio's figures, The light and shadow of money cannot be separated and are constitutive. Looking forward, we have the speculative cityscapes in the future. We have the world of cyberpunk 2077, where money doesn't live in pockets or wallets anymore, but in our retinas. So if I look at you, I can transfer my assets to you. I don't know if you've seen that YouTube video. It is quite frankly horrifying, but there we are. Now imagine that, a world where microtransactions occur via eye contact, where reputation becomes currency, where debt is collected through automated implants. In such a world, the boundary between finance, identity, and the body itself dissolves, and it's no longer science fiction. Biometric payments are here. Brain-computer interfaces are already in development, and the question is no longer whether this future will arrive, but under what rules, under whose morals, and in whose interests. And this is what we're discussing here today. So just returning full circle to the Yap Islanders, to Caravaggio, and to code. They remind us that money is one thing. It has always been a human project. It is crafted from law, animated by our values, and projected into the future. I will stop here to thank our organizers, the European Banking Institute and University of Florence, Professor Filippo Zatti, Professor Rosa Giovanna Baresi, Dr. Chiara Ferri in the back, and the entire organizing team. It's been a privilege to be with you. Thank you for sticking through with me despite lunch on the horizon, and thank you for having me.
Thank you.